Anthony, welcome.
Thank you very much, Don.
It's been a while since we sat in the room together here.
It has. It feels like it's been a while since I've seen anyone in person in general, so it's nice to be here.
Well, God willing, the vaccine is coming, and maybe within 6 months, maybe things will start getting to be normal again.
Yeah.
How's your family holding up with all this?
We're doing okay. We're eating a lot and watching a lot of Netflix, probably not exercising enough, but we're making it through. Just kind of holding things down, I guess.
Yeah, I kind of feel like we're at the peak of it right now because we're experiencing the surge.
Right.
And the numbers are astronomical. I mean, it's scary and shocking to everybody. I mean,
Right.
when they said it was coming, I don't think anybody anticipated it'd be like this.
Exactly. And it's a little disappointing that the holidays are right around the corner too, and all those activities and gift giving and family dinners, you're probably going to have to do some modifications to that right now. So,
Yeah. Well, speaking of that, do you guys have any modified plans for Christmas and Thanksgiving and all of that?
yeah, so actually for Thanksgiving, we're going to do a separately kind of organized Thanksgiving dinner. We're all going to sit at separate tables. We're all going to be outside, trying to do the best way to keep everybody safe as possible.
That'd be fun.
Yeah, absolutely.
It's not an original thought. I found out from watching TV, but the thought is we can invite as many people as we want, so long as they get COVID testing before they come to the party. And I mean, that was my thought. I thought, hey, I'm brilliant.
Yeah.
And now they're saying, well, yeah, but you could catch it on the way there, right?
Yeah, exactly. So, I think you still got to be a little bit careful testing or not. So
yeah. Very interesting how the country, the world is learning how to deal with a pandemic, and it's been like we didn't learn anything 100 years ago. We didn't look back to 100 years ago and be prepared for this. It seems it's like the masks were important, then it wasn't important.
Right.
It was to protect only the person that you could possibly sneeze on. Now it could protect you.
Yeah.
I mean, there's just so much that we're learning, but fortunately, I think that the vaccines are going to bring spirits up at least.
I hope so too. Yeah. Hopefully we can get Pfizer and Moderna working full speed to get those ready for public use.
Yeah, and I know the government is paying for a lot of stuff. I just hope they put their resources behind this because the country needs it.
Absolutely.
So we're going to talk about kind of an interesting subject today. It's going to be about sanctions in family court.
Yeah.
And when I say sanctions, what am I really talking about?
Well, sanctions are a really fun topic, I think, because sanctions
for you because you're so good at getting them. But go ahead.
Sanctions is punishment, right? We're talking about punishment for bad behavior, and specifically, Family Code provides for a specific type of punishment under Family Code Section 271, where one attorney or one party engages in behavior or tactics that tend to controvert the public policy of the state to facilitate reasonable settlement of cases.
Are you telling me that in family court people misbehave, sir?
Unbelievable, right? Unbelievable. Yeah, one would not believe that actually in family court, some people might misbehave on their cases. So
so much so that they had to create a statute for it. So tell me about the types of behavior that 271 might apply to.
271 gets thrown around a lot. I encounter issues where other parties don't respond to settlement offers within a reasonable time. One party comes to the table with something really unreasonable, or they file unnecessary motions, a lot of inappropriate communications. There might be arguing or bickering, things like that. A lot of things fall under the realm of 271, and the courts really kind of adopted this provision because they wanted to reintroduce some civility and some reasonableness to the family court separation process.
Yeah, otherwise people have no reason to behave, and they can make these things go on and try to win by attrition and all that stuff that we see. And people actually do that, but sanctions are applied. So
They do.
Wow. Okay, so we're going to talk about two separate recent appellate court decisions.
That's right.
Okay, concerning sanctions. We're not going to cover every nuance in Family Code Section 271, which is the sanction code, and there's other codes. We're not going to go through this as in a lesson on all the things you could learn, but we want to kind of bring up to date some of the recent cases and some of the things that they said. So why don't we start off with the lightweight one first?
Okay. The first case is going to be Nicole George versus Kayvon Sham Shirazi. The appellant is Mr. Shirazi, and he's seeking relief from an order of sanctions that were awarded in the amount of $13,000 coming from a final judgment in a paternity case. The problem is he didn't wait. He waited quite a long time in order to try to get those sanctions.
So let me stop you there. He's trying to get sanctions against his ex-wife
Oh no, he was.
or ex-girlfriend or whatever it was.
That's right. So
Okay.
his ex-girlfriend was able to get a sanctions award against him in the amount of $13,000.
Okay.
But he didn't like that, so he wanted to seek relief from those sanctions, and ultimately he was not able to do so. There's a civil code rule of court that basically says that any type of post-judgment sanctions request must be filed within the period of time that you have for an appeal. That code applies to civil, contested cases. Civil cases are things that involve either like personal injury or business disputes, things like that. But there was a question of whether that applied to family law cases or not, and specifically whether that applied to 271 sanctions. And we think about that because 271 sanctions usually come up at the end of the case. You usually make that request after all the other issues have been decided in the case, and now the courts will turn to the behavior of the parties during the proceeding. Well, the way that issue gets determined usually follows some type of final judgment. So what happened in this case is that Mr. Shirazi waited, I believe it was 226 days to try to seek relief from it, and the court said, well, it was a little bit too long for you to seek relief from those contempt sanctions. Oh, sorry, not the 271 sanctions.
Yeah. Okay. So the timing is everything.
Timing is everything.
Okay. It's been a while since I've read this decision, but is there a difference between seeking sanctions that derive out of behavior during the pendency of a divorce versus post-judgment conduct?
No, you are entitled to sanctions both for.
Here's what I mean. Maybe the question was wrong.
Okay.
Let's assume that you're timed out from seeking sanctions for conduct that occurred while you were divorcing your spouse.
Mm-hmm.
But post-judgment, there's a lot of nefarious conduct going on,
Right.
withholding the children, harassing, saying, nasty things,
Right.
that the court's going to frown upon. Is the court precluded from issuing subsequent sanctions? And when I mean subsequent to the judgment
Right.
being entered?
So this is an interesting take on the specific language of 271. And 271 specifically says frustrates the policy of the state to promote settlement of cases. And when we talk about settlement can be settlement of the initial proceeding, but also that has been expanded to apply to post-judgment motions. So any issues or disputes that come up after a judgment's already been entered or following final trial. So yes, you can file a request for sanctions after the case has already been decided, but only as to issues that have arisen after the judgment. So the court doesn't want people to be waiting, 226 days. I think in this case, there was discussion that the request was made when the other party was on a maternity leave for 5 months, so that the timing issue was obviously calculated to prejudice the other party's ability to defend against it.
Okay, yeah. So they have to be brought timely. I mean, you can't go back. I was in court today. Not going to name my client or the opposing party or anything like that, but this was a criminal matter with domestic violence alleged, because we do both. And the alleged victim is claiming that the client had engaged in domestic violence 4 years ago.
Right.
And the police wrote it up and was submitted to the DA. And I'm thinking, isn't there such thing as statute of limitations here?
Right.
And, it was very interesting. So the law really does protect against people bringing things up way in the past.
Correct.
And particularly in family court, right?
Yeah, so there's a principle that's, I think, come up since very, very olden times called latches. And basically, if you sit on your rights to go and obtain some sort of relief, and you wait to do so in a way that prejudices the other party or it impedes their ability to defend against that request, you can be barred from getting that relief. So in this case, 226 days the court felt was a little bit too long. It needs to be brought a little bit earlier. They did specifically say that Cal Rule court section, though, didn't apply. So the request doesn't have to be 60 days, but it can't be 226, I don't think.
Okay. Now let's go to the more complicated case.
Okay.
And this is actually more fun for me. So
this is an interesting one because you deal with contempt a lot.
Yeah.
As a former DA, right? And
I'm not in contempt a lot. I either prosecute or defend contempt a lot.
That's
right.
That's exactly what I'm talking about. So we have a case now in which a party is seeking contempt against another party. But in conjunction with that contempt request, they're also requesting 271 fees. And basically, this has to do with a transfer of marital property. Basically, without going into all of the details, it was an unpermitted either transfer in violation of either the automatic restraining orders or a court order of a piece of property to, I believe it was a foreign country. I think it was Brazil.
So let me stop you with the facts here. Is that
Yeah.
now you're kind of refreshing my memory. So we've got this husband and wife that are having a contentious divorce.
Right.
Right. They go to trial, and wife is ordered to do something.
Correct.
She's ordered to transfer title to hubby. Right.
That's right.
And the property that's in question is in a foreign country where she's from. Right.
Correct. Yeah.
What country was that?
It's Brazil.
Okay.
Brazil.
So she's messing around all this time, and the court's continually making orders for her to do things, and she's
Right.
not doing them. Then it comes down to the specific order. You will transfer this property to him that's in Brazil. What
Right.
happens next?
I don't think she does it. I think she does it either does it in a way to spite him or just ignores the order altogether.
Yeah. So what she does is she transfers it to a family member down there through her attorney in
Right.
Brazil. And in Brazil, the court's like, yeah, okay, we'll transfer it, not a problem. And they basically ignore the American order, right? Okay. So she's violated, and she's done it through a certain way. So what happens next?
So now husband wants to go in and get, number one, a contempt order because she violated the court order knowingly and willingly, and she had the ability to comply. But in addition to that, he wants attorney's fees and sanctions, and the court grants it. They grant it in the amount of, I believe, $200,000.
How much did he originally ask for? It's like 400,000.
Yeah,
right?
exactly. So we see a lot of times the courts will cut down these sanctions requests because everybody goes in with the best number that you can, and hopefully if you miss the moon, you fall among the stars. But the petitioner in this case is going to go to appellate court and try to request relief, saying that the appellant's sanctions request was based on anticipated fees rather than fees that he actually incurred.
Okay. Meaning that when he was pleading for his fees, he told the trial court, hey, I'm going to have to expend more money
Right.
on attorneys and costs for having to get this done.
Exactly.
Right? What did the Court of Appeals say about that?
The courts agreed, actually saying that they need particularity in terms of the amount of sanctions that can be requested. So the court basically said that there wasn't sufficient evidence demonstrating that the $200,000 was charged or tethered to any anticipated attorney's fees or costs. Therefore, additional facts and documents and information needs to be elicited.
Interesting. So the way that I read this case is that it has to be tethered to actual fees and costs.
Right.
Now, it didn't say that a trial court can't award future fees, but it's got to be broken down.
That's correct. So
Yeah.
it did specifically say that the trial court can award 271 fees for anticipated future fees.
And that's a victory for the good guys. I mean,
Exactly.
To an
Exactly.
extent, you don't have to come back to the well. You could say, give it to me in advance because this is what I think it's going to cost.
Especially, I think, when you're dealing in a case where a party has been consistently violating court orders and there's an expectation that you're going to be successful on that fee request, the number is certainly going to be up for dispute. But there's an expectation that due to the history of behavior of that party, that party's going to, the ultimate other party is going to be able to obtain a fee order.
Yeah. Now, the one thing that the husband was shot down on the Court of Appeal was throwing extras in there, like his plane fare.
That's right.
And other things like that.
Right.
So what did the Court of Appeal say about that?
They said they have to be reasonable or reasonably associated with the
Fees and costs. Right?
Exactly.
It can't be, if you spend money on plane tickets, your hotels, that's not covered under the code.
exactly.
Right.
So
Interesting. Okay. So it sounds to me that we learned two lessons from these two cases. Okay. To sum up, going backwards to forward is that you can't ask for anticipated fees.
right.
Okay. They've got to be tethered, though, closely tethered to
Closely
fees and
tethered.
costs. You can't just say, I estimate it's going to cost $200,000.
Yep.
Okay. And with respect to the other decision, what do we learn from that?
We're learning that if you are going to go after fees pursuant to behavior that occurred before judgment, don't wait too long to do so. You don't have to do it within the civil period of time, but you also have to do it within a reasonable period of time that doesn't prejudice the other party's ability to defend against it.
Cool. Well, I'm glad that we went over this. This is technical stuff.
Yeah.
You're good at the technical stuff. I wanted to start today's program by saying that you're on a string of victories with technical stuff, but we won't get into that. So cool.
We enjoy the 271 subject just because it's so fun, right? We deal with really negative behavior, both on the part of other parties and as well as other parties' counsel a lot of the time. So a lot of the time we're trying to get orders to reduce the animosity and the hostility in these types of cases, which is exactly what the statute is designed to do. So we evoke this part of the law a lot, and we use a lot of these cases quite a bit.
Cool. Okay. Well, thank you for joining us again, Anthony.
You're very welcome.
Come back soon.
Happy Thanksgiving.
Okay, you too.